Your Honor, at this time, at the end of all of the state's evidence, the defense moves for acquittal for the reasons that the evidence that's been produced so far does not prove beyond a reasonable doubt that the allegations of the trial information have been established. The evidence is speculative. The evidence is uncorroborated testimony from one witness alone who claims to be the victim in this case. The evidence is contradictory as to the age of the victim. She had testified earlier, and she admitted that she did, that she was 15 or 16 at the time the initial alleged sexual misconduct took place. I do not believe that the weight of the evidence leads to the ultimate conclusion that without further explanation, the defendant is guilty. I believe that submitting the issue to the jury at this point is asking for speculation, conjecture, surmise, and would be improper, and for that reason I do move that the court enter an order of acquittal at this time.
Mr. Smith?
Yes, Your Honor. Thank you. The state would resist defendant's motion for judgment of acquittal. As the court knows, the standard is not a reasonable doubt at this point. It's whether or not the state has a prima facie case, the case to be submitted to the jury. We had the victim testify and as direct evidence of the allegations. And so I guess what I'm trying to say is there's a prima facie case when the evidence is looked at in the light most favorable to the state, and for those reasons, the state would resist the defendant's motion.
Taking the evidence in the light most favorable to the state, the court finds that the state has established a prima facie case. The motion for acquittal, judgment of acquittal is denied. Should we bring the jury back? Or?
There is another issue I'd like to take up with the court while the jury's not here, Your Honor. I'd like to revisit partially the issue of the state's first motion in limine, and in particular number 5, any reference to the victim's past and present relationships, that is, engagements, courtships, etc., said evidence not being relevant under Iowa rules. It is the intention of the defendant's witnesses to testify that the complaining witness, Kayla, was in an emotionally fragile state at the time that she made these allegations, which were made maybe 9-10 years after the initial incident was alleged to have happened. We are not using any evidence for the purpose of indicating that she is a person of morals, that she has any previous particular sexually active past, or to impugn her character. But the testimony, if allowed to be offered, would indicate that she was having difficulties in her relationship with her fiancé, that she was having difficulties at home in a strained relationship with her parents, and that she kept coming to the Pfister household and to the Pfister family for supper and support. And that it was in this fragile state at a time when she did finally break off her engagement and leave her fiancé that she made this allegation against Scott. And I think it's relevant to her motivation and therefore to her credibility.
One second, Your Honor, I'm looking for something. I guess first, all the information, if defendant plans to put that information on that proves the contention that for some reason the victim in this case fabricated these allegations or made them because she was distraught or whatever. This is the first the state's hearing of it. Granted, this is kind of how the system works, and I understand that. But I wanted to find, at the time this allegation was made, Your Honor, this this case the charge was filed about a year ago. And I believe at the time, and I could be mistaken, I believe at the time that the victim and her then boyfriend or fiance were still boyfriend or fiance. And I don't understand how, if it's the defense's, allegation that she was dumped or she broke up with her fiance because of what Mr. Pfister had done to her, that doesn't make a whole lot of sense if, in fact, they were still together at that time. And I'm looking for the interview because the boyfriend was interviewed at the time. And that's what I'm just trying to look for, Your Honor. I guess I don't need to look for it. If the court believes that the defendant, some reason or another, in order to be afforded a fair trial, in order to poke holes in the state's case, needs to prove the motive, or a reason for the victim to come forward, then I guess that may be appropriate. But there was an uncontested motion in limine on this issue yesterday, and it's just kind of not something the state's prepared to deal with. But take it as it comes, I guess.
Clarify for me what your resistance is, if any, then.
I apologize, Your Honor. Resistance is that it's not relevant. It's only become relevant because defendant, we're in the second day of trial and he doesn't have any other defense other than what evidence he's going to put on now concerning relationship issues that the victim was supposedly having, of which the state has no evidence of. So I guess the objection is more along the lines of, we agreed, or at least the defense agreed in the motion in limine that this was not an issue, but now today it is. And the state's had no time to prepare or, to look into, to the allegations so they can rebut defense's contention as it relates to these matters.
Mr. Schulte?
The defense does not intend to blindside the state or its evidence, but you often don't know exactly where you are in a case until you've heard the evidence. And now that the state has presented its evidence and now that the state has rested, I am being told that Kayla had indicated to different members of the family that she was looking for a way to get out of this emotion. And that happened at around the same time that she did these allegations against Scott. I guess the implication is that perhaps there is some motivation to make an unfounded allegation if that's what she did.
Well, I'm a little confused because when you first made your argument, you indicated that it was because she had the relationship had deteriorated with the fiance and had broken off, and she was seeking succor from the defendant's family. Now you're indicating that the allegations were a means of breaking that relationship off. Is it one or the other, or is it both?
I think it's a little bit of both. I think that she's wanting to break the relationship off, and she's looking around for ways to do that. I mean, the evidence also might indicate, again, it has nothing to do with her moral character, that these two people have a child together. And that she's placing the child in the care of Scott and his family most of the time. And when we see her, she keeps reaching out. She's always emotional. She's always having difficulties. And she talks about being unhappy in a relationship. And then out of the blue, this comes. All at about the same time. Is it exactly right after she broke off the engagement? Is it a few weeks before? I simply don't know. I'm not even sure that any of my witnesses would remember exactly the timeline on such things, because life just flows on and things happen and things come and go. But it's the general intention of the defense to offer some kind of explanation why she would fabricate the allegations that she has made.
I don't understand the logical progression from seeking assistance from the defendant and the defendant's family and seeking shelter from them, and then making an allegation against the defendant, which would seem to be directly contrary to a longstanding pattern of seeking assistance from them. I think that that is contradictory.
I think it is too. And I think that's what the whole family here is struggling with. They can't understand this.
Well, if it's contradictory, then I'm led to the conclusion that the underlying purpose for it is to do the very thing that we're not supposed to do, and that is impugn her reputation, her sexual proclivities, the fact that she has had a child out of wedlock, those sorts of things. So unless there's a direct connection, or even a logical connection under some circumstance, I have a hard time understanding why this would be appropriate testimony in order to establish some vendetta against the defendant. I just don't understand the argument. I think if it's a justification under an argument of relevancy, then it fails. I don't see how it is relevant to prove that point, that if she is drawn to this family, and I think there is sufficient evidence in this record for there to be a grant of the request that leave be granted from the motion in limine to show the closeness between the alleged victim and the family. The state, in the interview with the deputy, has established that the defendant, or the victim herself, the alleged victim herself, has testified that she was having problems at home and that she sought emotional assistance from the defendant. So I think that that is an appropriate issue. But to talk about, to go beyond that, to somehow create a situation where she is attempting to chastise the very person she's seeking assistance from is too big a leap at this stage of the record. Not sure that's a very clear ruling.
I guess, Your Honor, two things. One, the state has given the defendant a lot of latitude as it relates to adding witnesses late, and that's just been the policy of my office. So long as we have sufficient notice, the witnesses that were, I was told that there were 3 witnesses, now there are 4, and that's fine, but when asked for just a summary of what the witnesses are going to testify to, so I don't have to take depositions. None of the information that we're talking about today, the defendants raised now concerning Kayla Smith, was included in that summary. So that kind of goes along with the surprise element of this. Number 2 is I might be missing something, but I don't know how this information comes into evidence, even if for some reason it is relevant, even if for some reason the witnesses are allowed to speak on it. It seems to me it would come in as hearsay. It would have to come in through other means that of which the witnesses don't have firsthand knowledge of. But I could be mistaken on that. So that's just something I guess also to consider and add.
I think the main thrust of what my people are telling me is that she came to them because she was upset and in a fragile state of mind, for whatever reason. and that they would try to comfort her. And then she went off to school, and apparently she was unhappy.
Well, I think we had the interview, and the deputy's discussion with the defendant in the interview, where the defendant has already testified, and it's already in the record, that he sat there the night that the tire blew on the car and spent considerable length of time with her because she was having trouble with her student loans, with her family, and I'm not sure about the relationship. So that's already in the record. I don't see any problem with that being communicated to the jury by other witnesses. There's also testimony in there from that interview that she'd spent a considerable amount of time out at the farm, and I think that the defendant even testified that at one point she wanted to move out there with her. So the closeness of the relationship, and that's not even talking about what the alleged victim has testified to concerning her close relationship with the defendant. That's fine. But going beyond that and talking about the specifics of her relationship with this fiance or the breakup with the fiance, I think is irrelevant. I just don't see where the specifics of that do anything more than make the alleged victim less likable or impugn her character. If as the testimony goes along, there's something that comes to light that makes that more logical, we'll revisit it then. But I think that the specifics of that relationship with the fiance are covered by the motion in limine, and the court stands by its prior ruling. Anything else?
I want to know this stuff.
Okay. Why don't we take about 10 minutes then, and we'll see what
Please stand.